Today, we're going to discuss state and federal courts and the way they're organized and the appellate process. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. To start today, I want to lay out a few things that I think are important for our folks who watch from across the ocean. I have noticed comments from places like Australia, England, uh, Ireland, Scotland. There are a lot of extraterritorial people who are interested in American law and tend to watch this channel. So, one of the questions that I had, and I've seen it several times, is how does the appellate process work? What happens in state court with appeals and that sort of thing? So I wanted to go over a little bit of the organization of the courts for those folks. And if this isn't interesting to you, you can certainly feel free to skip this one. There'll be more substantive content. I've already posted a substantial, trial related video today, but I wanted to get this one out so that people would understand our system and how it works. So first I'm going to go over how they're organized and how the appeals proceed, and then we'll talk a little bit about appeals in criminal cases. So we're going to first look at state courts. So up at the top of this diagram, you'll see municipal court. This is sort of our traffic ticket court. It could be a city court. It could be a county court that is at a very low level. Basically, it handles things that are no more than a misdemeanor. No felony can be tried in municipal court, and no actual civil suit can be tried in municipal court. So if you get an adverse result there, you can appeal it up to either the associate or magistrate court in most jurisdictions. An associate or magistrate court generally deals with actions that involve less than $25,000 in terms of civil actions, and they generally don't handle felonies. They do sometimes handle misdemeanors. So again, it's a lower level court for instances of crime that are not particularly significant. Speeding, parking in the handicap slot, which really annoys me. So if you took it up to the associate or magistrate court and you got a bad result and you wanted to appeal it, you could usually appeal it to the circuit or district court. It depends on how the courts are labeled. Some places call them district courts because they comprise more than one county. Some places call them circuit courts because the judges used to ride a circuit. Irrespective of which designation is used, it is the principal trial court level in that state. That's where serious felonies like the Karen Reed case get tried, governed by the rules of criminal procedure, all of that kind of thing. They will make a record at that court. A lot of times in the associate and municipal court levels, they don't have a court reporter. Sometimes they will audio record the action, but most of the time they don't. So if you need a record, you usually get it at the circuit or district court. Now, in addition to the above, there is one other level there that is called the small claims court. It's more akin to municipal court, and it feeds into the associate level or the magistrate level. And again, if you don't get a good result there, you take it up to the district court or the circuit court. From there, it goes to usually an intermediate court of appeals. In Missouri, it would be called the Court of Appeals for the Eastern District and the Western District and the Southern District. The three district courts of appeal there. Then, if you don't get a result that you like, you can ask for an appeal to the state Supreme Court. And when I say ask for an appeal to the state Supreme Court, that's what I mean. You see the little box that I've put around there, other than the green box? The little box there is to indicate that the state Supreme Court is not an appellate court of right. In other words, you don't have the right in most cases to take your appeal to the state Supreme Court. Generally speaking, in most systems, the only people who have an absolute right to go to the state Supreme Court are the people who get a death penalty verdict. But everybody else can ask for the state Supreme Court to review their case. The state Supreme Court, like in Georgia, doesn't have to. It can say, no, we like the Court of Appeals opinion. We're just going to leave the Court of Appeals opinion. And indeed, that's the way it works in Missouri as well. But these intermediate courts do sometimes misstate the law, or they create a conflict. A district court of appeals in one district will decide an issue one way, and another district will decide it a different way. And the court of last resort, whether it's called the state Supreme Court or the Court of Appeals, in New York, they don't follow this naming convention. They use a different naming convention. But the court of last resort will sometimes take conflicts between the intermediate circuit courts and try to make the law clear in that regard. And then, if you get an adverse result at the state Supreme Court, the only thing you can do is take it up to the U.S. Supreme Court. But, and this is an important but, the appellate reason has to be a constitutional issue, a U.S. constitutional issues. So if I, as a Missouri lawyer, ask for an appeal that deals with a Missouri constitutional issue, in other words, something peculiar to the Missouri Constitution, like they have a rule against log rolling. In other words, using somebody else's bill to add stuff on your bill that doesn't fit within the title of the bill that's being offered. Well, in that situation, the state Supreme Court is the final word on state law issues. But if it deals with something like due process or the Commerce Clause or an issue of federal preemption, for example, then it can go, although doesn't necessarily have to go, to the U.S. Supreme Court. What happens if you're going to take an appeal to the U.S. Supreme Court is you draft a petition for a writ of certiorari. And essentially, what you ask the Supreme Court to do is request the record of the lower court be sent up to it so that it can review that record and determine whether or not it wants to hear that particular case. It oftentimes takes a lot to get into the U.S. Supreme Court, but novel issues that haven't been decided previously, and sometimes issues that have been decided previously, but that the court now deems to be decided wrongly, it can come back and review that case a second time or make new law on that subject. But that's how the state Supreme Court feeds into the U.S. Supreme Court. Now let's take a look at the federal appellate process. Federal courts at the low level have two different kinds of courts. The first is the magistrate judge. The magistrate judge usually handles misdemeanors. It handles, if you get a speeding ticket on an Air Force base or a military post and you're a civilian, it's going to be dealt with through this magistrate judge. If you get into a fist fight with somebody who is on an Air Force base or something like that, and you get charged with assault, again, it's going to go to this magistrate judge. And then the other level of court that is a little bit lower than this federal district court is the bankruptcy court. The magistrate judge is not an Article 3 judge. That's because he is not appointed by the president, confirmed by the Senate. Rather, he is appointed by the judges of the federal district court, and he serves for a certain period of time. So, as a result, he does not have Article 3 power. He can't adjudicate a case that arises under Article 3 of the Constitution unless he essentially borrows some of the federal district court's Article 3 power through a designation. A lot of times in district courts where there are really high-level cases going on and federal judges are kind of overworked, some of the civil cases get turfed down to a magistrate judge. In fact, the magistrate judge in the case involving the Idaho professor who sued for defamation, it was being handled by a magistrate judge because the parties agreed that that magistrate judge could hear the case because it would likely get through the court system much more quickly than it would if it was handled by a federal district court judge. And then the other court down here on the other level, the bankruptcy court. The bankruptcy court is not an Article 3 court either. It's an Article 1 court because it was created by Congress to adjudicate bankruptcies. And as a result, when somebody takes an appeal from a bankruptcy court, it depends on what the scheme is in the particular circuit court of appeals. Normally, it goes to the federal district court where it sits. So the bankruptcy court in Missouri would go up to the federal district court in either the Eastern or Western District, whichever of those two the bankruptcy court was sitting in. But in some states and in some federal circuits, it goes to something called a bankruptcy appellate panel, which is loosely affiliated with the numbered Circuit Court of Appeals. Now, the numbered Circuit Court of Appeals handle everything that comes up from the federal district court. And the federal district court sends up a record to the numbered Circuit Court of Appeals. Then, whether it's the 8th Circuit or the 9th Circuit, 11th Circuit, whatever circuit it is, it handles all the appeals from that district. So, for example, the 8th Circuit Court of Appeals, which handles Missouri, handles Arkansas, Missouri, Iowa, and Minnesota. And that keeps them fairly busy. If you don't like the result that you get from the numbered Circuit Court of Appeals, then you can take it up again by asking for a writ of certiorari up to the Supreme Court. But the Supreme Court doesn't have to hear your case. They can say, hey, just like in state court, you're stuck with the Circuit Court of Appeals opinion. But again, in novel cases, they will take those cases up. Now let's talk about process. And by that, I mean, let's talk about what happens when you have a criminal case in state court and the defendant is convicted and believes they are wrongly convicted. Then they follow that same path. You are here in the circuit or district court level, and you appeal to the Intermediate Court of Appeals, and then if the Supreme Court will take it, you appeal to the state Supreme Court. And if you have a U.S. constitutional issue, you can bring it up and ask for certiorari from the U.S. Supreme Court. That's how appeals are handled in criminal cases in the state court system. But a lot of people have been confused about how there could have been a mistrial and then the case was being tried again. That is an interesting facet of American law. A mistrial is essentially, we're just starting over. Everybody screwed up. We're going to take another look at this. It's like the first trial never happened. Now, all of the testimony that came in the first trial is useful for impeachment later. But the first trial effectively never happened. You get a new jury and you get a new determination. A mistrial is usually caused by a number of things. A jury was poisoned by some comment or some piece of evidence that shouldn't have been admitted. Somebody said something in open court which had previously been excluded. Sometimes you'll have a situation where the lead lawyer who is handling the case is operating solo and has a heart attack or gets sick in a way that he can't continue with the trial, and the court will declare a mistrial. And in that situation, sad as it is, the defendant, if he's not out on bail, is going to remain in jail until a new attorney is appointed and can handle that case going forward. But that's the way the system works. But that's the way that the system works in terms of how a mistrial affects things. If you don't get a verdict and you get a hung jury, for example, that's a mistrial. You start over, you do it again. And it seems to be sort of unfair in some respects, but you have to have a unanimous verdict either to convict or to acquit. Everybody has to agree on that jury. And if they don't, it's second verse, same as the first. You do it all over again. And that can be confusing. In the Karen Read trial, the first trial ended by a mistrial. There are a lot of people, myself including, who believe that it shouldn't have ended that way. I believe the judge should have sent them back and told them, if there are counts you can agree on, bring me back a partial verdict. And if you can't agree on the last count, then I will mistry that account. If the state loses, the state cannot appeal. Now, they can appeal, they can make interlocutory appeals during a case and ask for appellate review on specific issues. For example, if a key piece of evidence gets excluded, they can sometimes take that up, but not universally. And as a result, that's why most lawyers will go into the court well before the trial date and say, we need this issue decided. Are you going to admit this evidence? And if the court says no, absolutely not, then they can file an interlocutory appeal and get an appeal up in front of the local court of appeals so they can get a reading on that. And a lot of times, if they can't get that job done, if they can't get that evidence in, they'll wind up having to dismiss the case. So that's the way the system works in a nutshell. If you have any questions, drop them in the comments below. I will try to get to them. I want to thank everybody who has subscribed recently. It has made getting to the comments very difficult because there are so many of them. But please keep commenting. I love it. Thank you so much. And I want to especially thank the people who've said positive things about the channel. I try very hard to keep this positive and upbeat and to make some of these things a little bit fun, like dropping the little thought bubbles over Yuri's head. Those are the kind of things that I think add a little something to the discussion and allow us to smile. And if we can smile, well, then we can have a little fun too. And remember, if you have the opportunity, I always ask this, try to do something kind for somebody today. That's one of the things that I think makes this channel a little different than others, is that I do believe in kindness. And even when people say things that are really not very nice to me, I try to say things like, bless your heart, because I don't want them to go away feeling like, you know, I don't like them. I just may not like their comment. And I think that's, I guess that's my problem, not really theirs. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.